It's an interesting case published, interesting decision published in the last few weeks there. It's a High Court decision, and it's where an employee on probation went to the High Court looking for an injunction to prevent the appointment of another person to her position and to seek other reliefs, for example, preventing the termination of her employment, ensuring that she continued to be paid, and so on. The background to this case is, the name of the case is Anna Buttermore and Oak Fuel Supermarket Limited, trading as Cost Cutter Rathcormac. Rathcormac is in County Cork. I've published a blog post on this particular case on my website, employmentrightsireland.com. You can have a look at my blog post there, but more importantly, the decision itself is in that blog post. You can click on it and you'll see exactly what the High Court decided and what the High Court was being asked to decide, and most importantly, the principles involved in obtaining an injunction, an employment injunction, the principles involved in a person being terminated whilst on probation, and whether the disciplinary procedure is an entitlement in that situation or not. In this case, Anna Buttermore sought a High Court injunction preventing her employer from terminating her employment, stopping the employer from replacing her in the workplace, preventing the employer from termination of her employment contract, and other reliefs. I think there were 6 reliefs sought in total. She was successful in relation to 2 of them. The background in the High Court. The background to the case is the employer has a shop and filling station in Rathcormac, County Cork. Miss Buttermore started her employment there in March 2022 as a supervisor. She was promised that she'd be appointed to the store manager position within a month. She was acting as manager from the commencement of her employment, however. Towards the end of March, an employee made a number of allegations against her. These included that she had accused another employee of being two-faced, and she used, allegedly, inappropriate language, amongst other things. Miss Buttermore saw these allegations as an attempt to have her removed from the job. The employer then engaged the services of an external HR firm who were to investigate the allegations in accordance with the bullying and harassment policy in the workplace. The terms of reference, interestingly, refer to the principles of natural justice will be applied at all times. This is important in the overall context of the case, because ordinarily an employee on probation may have a clause in their contract saying that the ordinary disciplinary procedure won't apply in your situation if you're on probation. But the terms of reference made specific reference to the principles of natural justice being applied. While the investigation was ongoing, Miss Buttermore was promoted then to the position of store manager in April 2022. Her contract provided for a probation of 6 months, extendable by a further 5 months. The staff handbook referred to the disciplinary procedure in the workplace, and it also defined misconduct. However, the standard disciplinary procedure was not to apply during the probation period, and this would be common enough. Her boss then, Mr. Mullane, received further complaints about Miss Buttermore by text message when the original investigation was still going on. He called Miss Buttermore to a meeting in May 2022 and told her that she'd failed her probation and was terminated, either at the meeting or later that day. However, at that meeting, Mr. Mullane offered her a job in a different store that he owned, apparently in Greena. This job would involve her starting a new 6-month probation period and a position as a trainee manager, as Mr. Mullane could see potential in Miss Buttermore to become a good manager. Miss Buttermore did not reply to Mr. Mullane's email offer, and the next interaction was Mr. Mullane received a solicitor's letter from Miss Buttermore's solicitor, demanding her reinstatement and claiming that she had been terminated as a result of the allegations made against her, without the opportunity to defend herself against those allegations, and in breach of fair procedures and the company's own policies. It was claimed that the trainee manager position that was offered was a demotion. Miss Buttermore then issued her legal proceedings seeking reliefs. The employer argued firstly that she wasn't entitled to any reliefs because she didn't come to court with clean hands. In other words, she engaged in, or her solicitor made some mistakes in defending or bringing the proceedings and so on, but the court didn't entertain that, and the judge did not agree, as the type of conduct that Miss Buttermore was accused of was not conduct of such gravity as to constitute unclean hands. The court then went on to look at the tests to be applied when an interlocutory injunction is being sought, and the relevant cases there are Campus Oil versus Minister for Industry and Energy from 1983 and the Supreme Court decision in Merck Sharp and Dome. We won't go into that now. You can have a look at the blog post and you can have a look at the decision itself on my website, Employment Rights Ireland. The plaintiff, Miss Buttermore, argued that she was entitled to an injunction as her employment was terminated on the basis of certain allegations against her without being given the opportunity to challenge the allegations or defend her position. This would be basically in breach of a person's right to natural justice and fair procedures. The defendant argued she was not terminated on the basis of the allegations against her, but was terminated because she had failed her probation period and her performance was poor and she was not the right fit for the store. The judge noted that the authorities are clear that an employee may be let go during the probationary period for any reason, including poor performance, or no reason, without any obligation to afford fair procedures. However, it is equally clear, as a matter of general principle, that while at common law an employer is free to dismiss an employee for any reason or no reason, where the dismissal or termination is for misconduct, the employer is obliged to comply with fair procedures. This is the nub of this case. The employer here could have terminated this lady's employment and not given any reason. The employer could have terminated this lady's contract of employment and done so on performance grounds and not have to give fair procedures. However, the employer cannot terminate an employee on probation on conduct grounds without affording fair procedures. In other words, if it's a conduct matter, you have a constitutional right to your good name and reputation. If there's conduct issues, you're entitled to fair procedures because you're entitled to defend yourself against the allegations, and that is absolutely key. The judge then in this case had to look at the question of on what basis was she terminated. The employer said she was terminated for performance and for failing probation. The judge decided, quite frankly, that she was terminated because of conduct reasons, or at least partially for conduct reasons. In other words, there was allegations of bullying and harassment against her, and these would give rise, if they were proven to be true, to constitute misconduct. And clearly, if something is misconduct, then she's been terminated for conduct reasons, and if she's been terminated for conduct reasons, then she's entitled to fair procedures and natural justice. To reiterate, there's no suggestion that the principles of natural justice must be applied where an employer terminates the employment contract of an employee on the grounds of poor performance. In other words, if the judge accepted that the lady's employment was terminated on the grounds of poor performance, she wasn't entitled to fair procedures and she wasn't entitled to an injunction. In this case, the judge had to determine if the employee was terminated for misconduct. If she was, then she was entitled to fair procedures, natural justice, and would be granted the injunction. The judge could not determine whether the employee was terminated for misconduct or poor performance, but he did decide that she had established a strong case that she was fired on account of the allegations against her. He then had to decide if the allegations against her constituted misconduct and thus attracted fair procedures and natural justice. He decided that the allegations against her did constitute misconduct as understood by reasonable persons. The judge also noted that the employer appointed an external investigator to carry out an investigation which might lead to a disciplinary procedure. This indicated that the employer viewed the allegations as misconduct issues. The judge also found that even if the contract of employment states that the disciplinary procedure will not apply during the probation period, all that means is that the company's standard procedure will not apply. The employee's common law and constitutional rights will still be intact, and the employee is still entitled to fair procedures if the allegation is misconduct. Fair procedures were not applied, the judge found, and granted the injunction, having weighed up the balance of convenience stroke justice and the adequacy of damages as a remedy for the employee if she was successful at trial. The judge agreed that the employee's good name and reputation needed to be seriously considered when weighing up if damages would be adequate if she succeeded at trial. Now, the judge did not give all of the reliefs that were sought, but gave two. And the bottom line is, from an employer's perspective, just to be clear on that, the judge, as is made clear in the authorities, the court has a broad discretion to arrange things appropriately to minimise the risk of injustice pending the full trial. The damage to the plaintiff's reputation and the defendant's acceptance of the importance of reputation is of particular relevance here. I will therefore grant interlocutory orders in terms of paragraphs 3 and 6 of the notice of motion. That is basically preventing the employer from appointing somebody else to her position. This does, of course, adversely impact on the defendant because they cannot fill the vacancy, but this prejudice must be weighed against the prejudice to the plaintiff if the defendant can replace her permanently or can make it public that her employment was terminated. It holds open the plaintiff's position and seeks to reduce the reputational damage that might be done if it is made known that the plaintiff was let go, even if her position is vindicated at trial. It also minimises the plaintiff's exposure on her undertaking as to damages. The takeaway here for employer and employee is this: an employee on probation can be terminated for no reason or on performance grounds without an obligation to afford fair procedures and natural justice. An employer must ensure fair procedures if the employee is to be terminated on the grounds of conduct, even if the employee is on probation. The case is Anna Buttermore and Oak Fuel Supermarket Limited, trading as Cost Cutter Rathcormac, and you can read my blog post and read the full decision in that case. It's a High Court decision, obviously, because High Court gives injunctions, on my website employmentrightsireland.com. If you find this video useful, I'd appreciate if you gave it the old thumbs up down below, and you may be interested in subscribing to my YouTube channel. Thanks a lot.